This is Will Salgado's Friday Night Live. No, I'm just playing. Anyhow, I should do something like that, huh? A little introduction. I go and give legal advice on Fridays. Usually it's at 6:30. I am going to be discussing the legal topic of the divorce process in the most basic of forms. And after that, after I do the live, I'm going to download it or upload it, download it onto my phone and upload it onto YouTube so that people have a basic understanding of what the divorce process is. This is a question I get asked on a daily basis, it seems like. Well, maybe not on a daily, but it's a question that most people want the answer to who are going through or are anticipating a divorce. So here we go. Essentially, the divorce process begins with the filing of a petition. It's called a petition for dissolution of marriage. You could also use the same petition if you want an annulment, for example, or a legal separation. That those themes are not the topic of this conversation tonight. That would be for another another live session, because those go into different reasons why you're separating, or different grounds as to why you're separating from from your partner. And so this is just going to focus on the petition for the dissolution of marriage. So if you're interested in getting a divorce, or you know someone who is interested or anticipating going through a divorce process, I'm going to discuss the basics tonight. So you file the petition first, the petition and the summons. There's another form that's called the summons, and then another form which is called the UCCJEA. That one's a tongue twister, and that's the Uniform Child Custody Jurisdiction Enforcement Act form. That document, hello, Minnie Balding. That document is basically used to report your children, in essence. So whenever you're going through a divorce, or you're doing a petition to establish paternity, you would include your children in that form, and you would disclose where they've been the last 5 years. It's something that the entire the states use uniformly to keep track of children, that way there's no kidnapping, etc. So you file your petition with the courthouse in the local county where you live. And then once you file it, that begins your divorce process. Remember that the petition is what raises the issues. And what the heck does that mean? That means that you have to check the box or write in what you want from your divorce. Do you want spousal support? Do you want child support? Do you want orders regarding your children? Who are they going to live with? What time will the visitations be? And so you don't have to go into specifics. You can at that time, but it's not necessary. And then you also, if you want, you list certain property and the characteristics of those properties. And I don't want to get into the technicalities of all that, because we could do a whole different session on that. Or the petition definitely is going to have the information that you want the judge to, or the issues that you want the judge to rule on later on down the road. If you forget to check one of the boxes, for example, if you forget to check spousal support, you can't ask for it down the road. You're gonna have to come back and amend the petition and have it reserved again if you already had it served before. So that's why it's important sometimes to talk to an attorney at the very beginning and get your ducks in a row from the very beginning. So once you have the petition filed, and you go and you serve that. Now, I did a video on YouTube about service. It's about 30 minutes long. I'm not going to get into how you serve someone, because that can get complicated also. But technically speaking, you hand serve the documents to your spouse or your domestic registered partner. But you can't serve it yourself. Someone else has to serve it who's over the age of 18 and is competent. Respondent, or the person who received the petition, who is your partner or soon to be ex-spouse, will at that point have 30 days to respond to the petition. And the name of the document is called, guess what? The response. So the respondent files a response, and from that point, they either click that they raise their own issues. So example, if you didn't check the spousal support box, or you checked that you wanted spousal support to be terminated, they could check that they want spousal support or that they want spousal terminated for you. I know that doesn't make sense right now. Maybe it does, but what I'm saying is that you get to bring up the issues that you want the judge to rule on if you're the respondent. Now, if you don't file a response, that's very bad. It can be very bad. If you have an agreement with your partner not to file a response and you're going to do what's called a stipulated judgment, then that's great. You have to be able to trust your spouse if you're going to be doing that, because there's a possibility that this person could take advantage of you if you don't file a response. I always advise that you should file a response anyways, and then come to an agreement through a marital settlement agreement if you have an agreement. That way your bases are covered, okay? So that's the initial filing steps. Those are the initial documents that are filed in a divorce. You have your petition with the accompanying documents, which I talked about, which are the summons and the UCCJEA, a confidential declaration if your county requires it. And then you serve that on your spouse or your soon-to-be ex. And then that person, the person who was served, is going to file a response. Once the response is filed, there's a time clock that begins. And that's a very important time clock because it's one of the most important questions that I get asked all the time. How long does a divorce take? A divorce takes... Hey, what's going on, Mr. Estrada? It's nice to see you. I hope you're still on here. I think you're gone. Anyhow, so the important time frame, or the clock, begins at that point, because you have 6 months of a cool-off period. That's what I like to call it. So basically, it's statutory. You have to wait the 6 months before your divorce can be final, and that's because the policy of the state is to keep married partners together. And so that 6 month waiting period, the clock begins to run once the petition is served on the respondent. I think I said once the response is filed, but that's not true. Once the petition is served on the respondent, at that point, the 6 month clock begins to run. 60 days after the response is filed, you have to each file what are called disclosures. Disclosures are exactly what they sound like. You have to disclose everything that is in your name or your spouse's name, and that can cause things to be duplicative, but it is what it is. So one spouse and the other spouse will have to fill out what's usually called a declaration of disclosure, and a schedule of assets and debts, and an income and expense declaration. There are 3 forms, and then there's a 4th form called the service regarding declaration of disclosure. That's a real form. So those forms, that's where most people who are representing themselves and are preparing the forms or going through the divorce without the help of an attorney or competent facilitator, get stuck, because the forms can be somewhat they are tedious. I'm not going to say that they're not. They ask for a lot of information. You have to attach statements, for example. You have to disclose everything: what you own, the furniture at your house, like I said, bank accounts, vehicles, trailers, pensions, retirement. So it's quite a bit. And so you also have to disclose your income and your expenses, the income and expense declaration. There is a lot of back and forth going on during this middle phase of the divorce where you're both disclosing information. You have to disclose everything, because if you don't disclose the information and an attorney finds out later on you're hiding it, that certain piece of property that you're trying to hide can be given to the other spouse as punishment. So make sure you're completely forthright and honest when you're disclosing the information in the disclosures. Okay. Now, I did skip an important part, and I wanted to skip it because I wanted to go back to it now. When you file your petition for dissolution of marriage, you open a case. You open a divorce case. Once you open a divorce case, you could do it at the same time or you could do it later. You could do it while you're doing the disclosures, doing the middle phase of your divorce. You can ask what are called temporary orders, or you can even ask for a restraining order if it warrants it, but under the same case. But and to simplify things, if, for example, you and your partner are not getting along on how you're sharing the children, you can file what's called a request for order and have the judge or a mediator determine how it is you're going to share or visitation or custody of the children. Same thing with alimony or child support. If, for example, during the course of the divorce, the mom or the father needs monetary aid in raising the children. I talked about child support in a separate video last week. Then you would file the request for order for child support so that the judge can hear and determine what the appropriate amount is on child support. Once you have a hearing for that, you're able to get orders right away instead of waiting until the end of the divorce to get your judgment, which would include all that. So those are the temporary orders that you get, and those will become part, for the most part, become part of the judgment, which is your final document. So we talked about the petition. We talked about the response. Once those documents are filed, you can also file the request for order if you want to bring up to the judge earlier issues or issues that should be decided earlier. For again, like I said, child custody, child visitation, child support, alimony, the division of property, the exclusive possession of property. So these are all the issues and there's many more. Who's going to keep the cat and the dog? Things like that could be discussed and brought up to the judge before your divorce is final. Because if not, you're going to be waiting 6 months. A lot of people think, oh, we could just address that 6 months down the road. But realistically speaking, most people don't have their paperwork ready by the 6-month mark, which I discussed earlier. And the final thing is, of course, would be the judgment. Now, the judgment is what divorces you and your spouse. If you are in agreement on all issues, which are the things I discussed earlier. So the issues are what you want to discuss with the judge. An issue would be child support, alimony, division of property, pets, pensions, things like that. The things that are the substance of the divorce itself. What is going to be divided as you guys get divorced or are separated? If you have an agreement on all those things or partial agreement, you could always put that down in an agreement through a marital settlement agreement or a stipulated judgment. Now, you could agree to certain things and then bifurcate or split off into another hearing or trial at that case. Because if you're at the very end of your case, you would go to trial at that point, and you would go before the judge to help you decide, who's going to keep Fluffy, the cat, or who's going to get what percentage in a pension or in a bank account, or who's going to get the down payment that was put in on the community property home. California is a community property state, which is something I'm going to do a video on later on in the future so that people know what they're looking at if they separate and divorce in California. California is one of the states where basically each party owns 1/2 of whatever was acquired during the marriage. And so and irrespective of who owns title, that's for another discussion. That's basically it. You either can come to an agreement at the very end, or you can let the judge decide. You can come to a partial agreement and put the things that you agree on partially as part of the judgment and let the judge decide the other issues. And then the judgment is prepared. The judge and the court do not prepare your judgment. You have to prepare it. I see it countless times where people go to court for case management conferences. Not all, and that's a hearing where the judge wants to know what the process of your divorce is. Other counties don't have that. Here in Stanislaus County, we have case management conferences, and the people go in there and they're confused because they think that the judge is going to prepare the judgment. You are wrong. You have to go in there and have the judgment prepared yourself. If you went to trial, the judge will prepare a ruling, and that ruling has to be part of the judgment. And so there's a few other forms too that you have to fill out. So that's why it's really important, guys, that you guys get the competent help of an attorney, or you guys go to the self-help center. I know there's legal document assistants that are able to help you. I can't recommend any ethically. And if you Google legal document assistance, they can help you prepare the divorce. There's many of them here in Stanislaus County. There's probably over 10. So there are people out there who can help you prepare the divorce paperwork. To summarize, so that everyone is aware of what we discussed tonight, especially those who are coming in late. The divorce process in its most simple form, the divorce process begins with a petition, and its accompanying documents, which include the summons and the UCCJEA. You file that with the court, and then you serve that on your spouse or soon-to-be soon-to-be ex-spouse, and then that person either files a response or doesn't file a response. And then there's what's called the disclosures, which we discussed earlier, and then there is the judgment at the end. So all that must take about 6 months, and I've had people come into my office say, "Well, I want to be divorced in 4 days because I'm getting married next week." And hey, I can't do anything about that. You got to wait the 6 months. So please, if you're considering going through a divorce, at least if you can't afford an attorney, consult with one. Some charge, some don't, but at least you get a general idea of what it is you're looking at, and you could explore whether a divorce is your best option or not. But there are other ways that I can explain the divorce process, but that's basically the process: the petition, the response, the disclosures. And those disclosures are 4 forms. I discussed them earlier. I don't even want to say them because they're going to tongue tie me. And then the final documents, which is your judgment. And those, even though I'm saying it, explaining that in the most basic form again, it can be complicated because there are documents that have to be attached to those documents. And sometimes there are what I like to call attachments to attachments to attachments. So please make sure you consult with someone and get competent help. You could try to do it yourself. There are plenty of resources out there. Hello, everyone who's joining me. So please do your best to be informed and search for resources, because the courts are not, and the judges are definitely not going to help you. I see it all the time where people who are self-represented go into the courts and ask the judges for guidance, and the judges are limited. They can't provide that information, much less tell you how to fill out forms. So I'll open the door now to see if anybody is willing to ask questions about the divorce process. Again, with the understanding that you do not disclose confidential information or information that could be prejudicial to your case. I also want to make a disclaimer that even though I'm a licensed attorney here in California, I am not your attorney unless you've come into my office and you've signed a client attorney fee agreement. And so again, this is just general information.